Hello, my name is Jay Chauhan. I'm a mentor at the Angel Mentorship Group, which is on the Facebook. And now we have members from different countries, including India, Pakistan, um, West Indies, and England. And we want to increase our reach to different jurisdictions, which are common law jurisdictions, and share common views on how this jurisdiction functions. But today's topic is more limited to Ontario jurisdiction with respect to how a deed is prepared in the current situation of technology and how to read the deed. So to help us frame the questions and also discuss is Ikra Tarim, and she'll be asking questions. I'll be making comments. I appreciate Ikra also you're making your comments on the bar materials that you're currently reading, and you're appearing on the examination very shortly. So what the examinations ask you to learn is also important for the students to understand, because our objective in the Angel Mentorship Group is to help new lawyers launch their practices. So anybody likes to join and launch their practice, please connect with us on the Facebook and with me so that we can bring you into the group. So here is so if you just introduce yourself and then frame your question, and I'll make a discussion around that topic.
Of course. My name is Ikra Tarim. I'm currently giving my solicitor examinations. I've passed my barrister. And today we're going to be discussing understanding the deed of property. And I guess my first question would be, how were deeds prepared in the past and how are they prepared today in Ontario?
Now, it's important, Ikra, and other people attending the seminar and others who are listening to this, is to understand the history of the evolution of the deed, which was a very important instrument through which an owner of the property expresses ownership. So for a long time in the English jurisdiction, the ownership was simply exercised by the owner, creating boundaries around his property. And as the system of registration evolved, the registry system was created. So the parties were asked to register their deed in the registry system, which created an announcement, if you like, to the public at large as to who the owner was. Then rules developed around Registry Act as to how you can register the documents. And I think those issues of how to register and how the system of registration is to be conducted in theory is showed in the admission course, but very often even a physical deed is not even shown. So today I will show to you, and we will look through the different parts of a deed for a person, both lawyer and a non-lawyer, to understand, because it is important that even a client understands what a deed looks like and how does it actually work to show the ownership of the property. So I think going back into the history, when the conflicts with respect to property began to be shown, in the English jurisdiction, which was brought to Australia, Canada, etc., the system was transplanted from the English jurisdiction to Ontario. So in terms of the registration of the property, once you register the deed, it becomes a historical record of the owner of the person who acquired the property from the last owner, and the transfer and the chain of title continues in the registry system. And when a lawyer is looking at it, he will certify the title based on the chain of ownership in the Registry Act. I think to improve the system of the chain and putting the responsibility on the lawyer to explain the chain of ownership, it was gradually moved into land title system, which was introduced in Ontario from England. And it essentially works by having the master of titles certify the title to indicate that the last owner from his register, which he maintains, is a particular person. If a mistake happens in this regard, it carries the fund from which the compensation is paid to the person who is affected by the title ownership. So there are two systems running in Ontario, one on the Registry Act, which are the older properties, and one which is the current one, more modern and more being in transition from registry to land titles, is the Land Titles Act system, in which the master of title takes the responsibility for the title ownership. So it's important to understand that the old system of the deed has now become a part of the computerized system, in which you can now look up the deed right on your computer, but you have to have access to that particular facility called TerraView. So I think historically, the deed were written out in handwriting, and in the legal profession, there were scribers who wrote the deed by hand, and they do a very good job of beautiful looking documents that describe the property by what is called meets and bounds, which is the description of the property with the compass that you take from one stake of a surveyor to another stake by the compass in a certain direction, and then you went into 4 pegs that were put around the property, and then in the direction that you went, and then you turn right and turn right again until you came to the original point, is a description on the deed called meets and bounds description. Now, all that was written out in great detail. In my days, when we were doing the deeds, we used to have 2 people actually read the deed, one reading the deed, another one listening to make sure that word for word the description was inserted in the deed and correctly, because you handed the deed over to the purchaser and you created one from the vendor and gave it to the purchaser. All of it has now been replaced, and as we talk, I'm going to show to you how the deed looks today. But in a summary, the deed that was handwritten once is today recorded as ownership in the computer system in the TerraView system, which is maintained by the Ontario government with a private organization. And each lawyer is required to be a member so that he can make a transfer of the property to another person based on his role as a vendor's lawyer or a purchaser's lawyer. So roughly, that's what the deed is all about, Ikra.
Sir, can I ask another question on this note? So, for example, if the deed that we're dealing with, it is in the registry system and not the land title system, do you need to convert it to the land title system? Is that like compulsory now when you are dealing with something in the registry system? Or is that not compulsory? Or is it something that's already happened?
It is happening by the day. So many of the properties, especially condominiums and new subdivisions, are required to be in the land title system. So what happens is that there is, in some places, a mass scale conversion, but in most places, it is a gradual conversion of the property. So let me give you 2 examples of how the conversion is taking place from the registry system to land title system. So if you create a condominium, as you can imagine that the condominium is showing a property in the space. So you have a ground where the ownership is expressed on a piece of land on a meets and bounds description. Then you build a building on it and you create a condominium. Each condominium unit, which is on the same space but on the higher level, requires the ability of the registry system to show the property, and that description of the property and the unit number are more easily described in the land title system than the registry. So first you have to, if you're a developer, you first convert the property into land title system, then you create and register your constitution of the condominium, and then each unit is then created out of one piece of land into many pieces of the land, so in a condominium. Similarly, if you create a subdivision, you have to go to the municipality and ask the municipality based on a plan of the development in which you show the roads, different properties, and you create out of one property several different lots. So in this situation, then you would also convert the property into land titles, register the property in the Land Titles Act, and you clean up all the title issues, and then you begin to show different pieces of land, each one of which would have a house on it and a separate ownership of the property. So the conversion is taking place, and most of it in Southern Ontario has been done into land title system, except for the cores of the cities where still the old system might prevail. But the conversion does happen on a regular basis of moving the property from registry system to the land title system, Ikra.
Thank you.
So, yes.
So I guess my next question would be, which statutes are applicable with regards to the registry system and the land titles system?
The two statutes that you're taught in the admission course is the Registry Act and the Land Titles Act. And the essential difference between the two is the Registry Act is the old-fashioned arrangement that was created to show simply registration, and the onus of showing the title was by proving a 40-year ownership in the name of the chain of people who owned it in the last 40 years. If a lawyer looks at the title and gives a certificate of title to the purchaser, then he can rely on it to say that he becomes now the new owner, puts the deed on the title, and then he's the new owner. That's roughly the registry system. The land title system is where you put the system into land titles, and the master of titles then says that he stands behind the ownership of the last person, and therefore he certifies the title. And if anything goes wrong, there is a fund which actually compensates the person who is prejudiced by the ownership, and that is maintained by the master of titles, and that's roughly the main difference. So in the system of learning, you learn the two systems, but the historical way in which one moves to the other, and in rationalizing the registry system into land title system is not fully explained. So it's important for the students to understand that, so that when you're practicing, you will come across these issues when you practice real estate law.
Thank you for that as well, sir. Also, if you could just explain the difference between meets and bounds and the PIN number, because I understand that the land title system now describes the property using a PIN number, which I believe is, as you said, more accurate than the system before, correct? The meets and bounds?
Yes. As I explained before, the old system was where the surveyor described the property by going from the one point in the property to the other point, and then turning at an angle right or left, and then again right or left, and then until you reach the original point. So this description is done by the surveyor. There's a whole separate statute called Surveyors Act, under which surveyors also carry out the function. And when Canada was settled, the surveyor was a very important profession. So his role, which is still in the law today, is to be actually surveying the property and describing the location of the stakes, and he actually bangs in an iron bar showing the starting point of the description. So the way the description is done in the meets and bounds description is that it takes a compass from that particular first point of starting, then looks at the next iron bar placed at another part of the property, and then you move along the compass by degrees that you describe, so many degrees up to the north and the east and the south and the west, and then you reach the original point. So you are describing the degrees is the direction on the compass as to which direction you're moving and how many feet are you moving. So the description method of going from one stake on one corner of the property to the next one is called meets and bounds description. Now, originally, all the description was put in the deed, but when the computers came in about 80s, the description of the property that the description of the properties were too long to be put in the deed, and the deed became very long and cumbersome. So each property was given a PIN number. So PIN number is a property identification number. So once you describe the property, the description was kept in the registry office and a PIN number was assigned to that particular property. So if you now look at the property in front of you, on the first part of the deed, you will see a numbering system. On the top left, first is the properties, and after that is the PIN number. And the PIN number is then describing the property. So if you take that PIN number and go to registry office, you'll be able to obtain the original description of the property. But for all intents and purposes, when you do conveyancing as a lawyer and convey the property from one person to the other, the description originally recorded in the registry office or land titles office is then assumed to be correct unless there is a dispute, in which event you open the register, look at the property. If there's any adjoining property which is having a dispute with your property, then you take the dispute and then deal with the dispute from the description that you have. But the PIN number in most cases is the conveyance of the property by simply the numbering system from one person to the next person. So the first column in the deed that you see is a description of the property.
Okay, thank you. Yes, I do see that. And it's interesting because you don't actually see any examples of what a deed looks like in the bar materials. So it's just funny that this is the first time I'm seeing that. And also, if you could just kind of explain how we do a title search, is that related to this in any way whatsoever?
Yes. So I think in the old deed, the property was described in the name of the owner. And then he conveyed the property to another person by sale of the property by or any other means, or even to a member of the family without the sale, but as a gift. There was what do you call the transfer of the property. So the vendor would be the person who prepares the outline of the deed, and the purchaser's lawyer then will look at the description and confirm that the way you conveyed the property in the deed with all the relevant description, the names of the parties are correct. That method of the original conveyancing method, which I used when I was young in Ontario and do the thing myself, but now you do it essentially through a computer system in which the vendor becomes the transferor. So the vocabulary in terms of computer system has changed from the vendor to the transferor, and therefore in the deed that you will see that the word used on the top of each column is the transferor or transferors in plural. And then there is a transferee. So the transferor is the person transferring the property from the vendor side. And the transferee is the person, is the purchaser who is receiving the property and becoming the new owner, is a purchaser of the property. So on the deed that is displayed in front of you, that you will see that there is the name of a transferor and then there's the name of a transferee. And that is how the transferor-transferee arrangement is described.
I see. I guess my next question would be, what is consideration in a deed?
Well, see, in the sale arrangement, when a vendor sells a property, he writes an offer to say that I am selling the property for, let's say, $1 million to the purchaser. That $1 million of the value is consideration. And when you convey the property in the registry or the land title system, in the TeleView system, you write the value of the property. And if you see this particular deed on the consideration is a second column from the top is consideration. Consideration is a legal word for the value of the property. So that was the word in the contract law that explained actually the value for which you're conveying a property for a certain amount of money, and that is the consideration. So in terms of the value of the property, which creates the contract of purchase, is consideration. Now, in today, it is expressed in the document called land transfer affidavit, land transfer tax affidavit. Actually, I'm moving it now to show to you the land transfer tax affidavit, which you can see has shown the various numbers, actually, the amount of the mortgage, the amount of the net family value to be paid, and the province of Ontario charges a fee for the registration of the deed on the title. So that is based on a percentage of the value of the property. So today's property, which are worth about $1 million or $2 million, that can be a fairly hefty amount of the land transfer tax fee. So it's become a tax. The tax is levied upon registration of the deed from the vendor to the purchaser. So the purchaser expresses by an affidavit the value on this particular affidavit, and the amount that is paid then is worked out in terms of the tax amount. You pay the tax at the time of registration, and that becomes a part of the revenue of the government in terms of the land transfer tax system. So I think if you have any questions, there is a separate ministry where you can reach the ministry to question. For example, if you have a non-resident, the tax situation is somewhat different, and you have to ask that amount. You have to then register the deed based on tendering the money that is required to be paid for consideration, which is shown on the land transfer tax affidavit. And then this amount is then shown in the affidavit of the purchaser, which is attached to the deed, and it becomes an important part of the document that you should preserve. So although the deed is preserved along with the land transfer tax affidavit in the registry system or the TerraView system, it is important to make sure that you have a record of it when the lawyer reports to you. So you should ask for a report from your lawyer when you have a deed transfer.
Thank you for that, sir. And one thing I just needed a little bit of clearance on, I understand that for vendor and purchaser agreements, you need separate lawyers, but are there any exceptions where you can use one lawyer instead?
Yes, I think in terms of the common law system evolved in England, and the civil law system evolved more in the continent. And therefore, there's a basic difference. Let's say in Canada, the two systems work separately. One in Quebec, where the civil law system operates, where one lawyer can be the notary that will do the transfer of property from the vendor to the purchaser, and there is no so-called conflict of interest. So he simply keeps a register without a conflict. In Ontario, the system was inherited from England, where the registry system became a part of the conveyancing system to the lawyers that were already established with the arrangement in common law, where the lawyer was required to protect the interest of only one party at a time. And therefore, since the vendor has a different interest than the purchaser, there are two different lawyers. So in most transactions, which are commercial, there will be a lawyer for the vendor and lawyer for the purchaser. So this is the arrangement to ensure that each person's interest is protected by the respective lawyers. Now, when there is a conveyance in the family members, there is no need for the parties to have separate lawyers, and the two parties can give a consent to the lawyer and say to the lawyer that we are both related, we are not charging the other person to change the ownership, and therefore can you accept and do the transaction for both of us. At that time, in a family transfer, you do not need a separate representation for or independent legal advice when it comes to transfer within a family.
Is ILA compulsory in that situation?
Well, I think you as a lawyer would have to make a judgment if there is any conflict of interest. So if you suspect as a lawyer that there may be a conflict of interest, then you should have independent representation to make sure that the person giving the property without consideration to the other person understands that once you give out the property and the name of the other party is recorded, then there is no turning back except for going to court to make your point. So therefore, it's very important that you make a decision whether there is going to be another lawyer or not. But that decision of whether there is a conflict or not is a question that is to be determined by the lawyer, who first attends to the client, who either says that I'm going to get the property from my relative, or the other person who says I have a property, and then do I need a lawyer or not? So the lawyer should be making an assessment. In the bar materials I saw, there is no explanation of who should make the assessment and how to make that assessment of the degree of conflict. So the degree of conflict makes a difference. So you have to make an evaluation, in my view, as a lawyer, that the degree of conflict is big enough to warrant an independent lawyer. For example, if the spouses are fighting with each other, and there is a lot of spouses are separating by statistics and numbers in Ontario, then you would consider where there is any hint. And if there is no hint of the conflict in the family, then you might want to ask the clients if there is no conflict of interest, and therefore they want one lawyer to carry out the transfer between the two related members of the family. So it's very important to have that understanding. And I was myself involved in one issue where I transferred the property to the daughter and the wife. And then I was questioned, actually, although I was not negligent because I had thoroughly recorded all the details of the request 4 different times. As you know, that if you're doing interview, there is a request that you have to say in that request that I want the lawyer to register deed in a certain way. Then you write a separate document as a lawyer to say that I do not want independent legal advice. So there were 3 or 4 different times when you have checking with the client as to whether or not there is a conflict. It's very embarrassing, if you like, to ask a client, well, are you having a conflict with your spouse? And it's not a question that you can ask easily. So the simplest solution is to really ask the client to write a direction and write it down the direction that there is no conflict. And if there is any indication of the conflict, you might want to then take the precautions and have a separate lawyer to carry out the other side's transaction.
And just, I guess, as an extra added measure to protect yourself from any claims in the future, you could just have a written acknowledgement saying that you've advised them for ILA and they want to go through with hiring one lawyer in an article.
Very correct. I think you made a good point, Ikra. So I think that it's the duty of the lawyer and to be sensitive. That sensitivity of how to assess and how to avoid the negligence is not sufficiently emphasized. So as a result, in Ontario, out of all the negligence claims against lawyers in the insurance system, the majority of the claims are in real estate. For example, I think that if you take the total number of negligence cases every year, about 36% are roughly for real estate issues. And that's very important. So I have, in my several decades of practice, never had a claim for real estate negligence or any other negligence, because it is my particular assessment on each transaction, how I deal with the client, how I make my assessment. And even if the material is not in the bioadmission materials, you take sufficient precaution to think out the issue before you simply mechanically get the client to sign. So we have very little time left now, 3 minutes. So you have time for one more question.
I guess just going over what is the lawyer's responsibility with regards to doing the search and closing. I think that's a good last question to ask.
Yes, I think the lawyer in the common law system becomes responsible when he's acting on the purchaser's side. So if you identify the role of the purchaser as a lawyer, then he would search in the land title system the last owner, in the registry system the last chain of title for about the last 40 years. And then you're in a position to say to the client in a certificate of title reporting letter that you've got a marketable title. if you are dealing with a bank, they will force you to sign a particular printed format which uses that word. If you look at the fine print, you will see that the fine print is requiring the lawyer to certify to the bank that the title is good. So the lawyer for the purchaser is looking for the title. And today's title has become much more complex than simply the ownership, because you must also deal with the question of
Any encumbrances on.
zoning, bylaw, and many other issues that, and executions and many other issues that are not necessarily traditionally ownership issues. So I think having said that, I want to wind up this session because we're running out of time, and I appreciate all of you. So I think that those interested in reconnecting, we can have a discussion, can reconnect on the same link. But this is a conclusion of the seminar on the deed and the transfer. Thank you, all of you, for being here today, and I hope to see you next week.
Thank you, Mr. John.
Thank you.